Let's do an overview of Trusts and Wills, by Columbine Law Group, PC. To contact us for a free consultation, please call 720-787-7870 or visit our website at www.columbinelaw.com. We will start with revocable trusts. Outright gifts to the surviving spouse, and testamentary trusts, are usually contained in revocable trusts. Revocable trusts are used for many reasons including, but not limited to, estate tax planning, protection of personal and real property, and avoidance of probate. Because Colorado has adopted the Uniform Probate Code, probate may not be very expensive, and the procedure is not difficult in some cases. If your goals include a revocable trust, one mistake is the failure to fully fund the trust. Upon creation of the trust, you will need to transfer substantially all of your assets into the trust. Even with the pour-over will, probate may be required in order to pour over the assets of the decedent that are outside the trust at the time of death, such as real property. Without a pour-over will, assets not transferred to the trust prior to death will pass by intestacy requiring probate. What is irrevocable trusts? Most of the time, revocable trusts become irrevocable upon the death of the first spouse. There are reasons to create an irrevocable trust, which may include charitable contributions, further estate tax planning, protection of assets from creditors, or to fund corporate obligations. Further tax planning may be necessary, and it is always advised that you speak with a financial planner and CPA as a vital part of your estate planning. Now let's look at simple wills. If the husband and wife have combined assets with a value substantially less than the current estate tax exemption 2017 amount is $5.49 million, and no minor children, or others for whom trusts are needed, then a simple will may be sufficient. Assets of the estate are defined as the value of the property less encumbrances. This kind of will usually makes outright gifts to the surviving spouse, and after both spouses have died, in equal shares to children. If any of the beneficiaries are minors, a provision can be included, creating a trust for anyone under or obtaining a particular age. If the estate assets are less than $66,000 for the year 2017, then a small estate affidavit may be sufficient to wrap up an estate after the surviving spouse has passed. If there is real property in the estate, regardless of the combined value of the estate, probate will be necessary upon death of the surviving spouse. Simple wills with contingent or testamentary trusts. If estate tax planning is still not needed, and does not accomplish your goals, then wills with contingent or testamentary trust may be recommended. These wills still make outright gifts to surviving spouse, and then to trust for the children. The trusts may be written to provide for the children through their school years and into their adulthood through a variety of options, such as monthly payments for their care, or a percentage of the trust at various ages. This information is not to be interpreted as providing legal services, nor as proposing any form of legal advice. Anyone considering a lawyer should independently investigate the lawyer's credentials and ability, and not rely upon advertisements or self-proclaimed expertise.